The question is that the bill be now read a second time. Mr. Christopher D. Souza.
Sir, the judiciary is an important institution. It helps to uphold the rule of law and plays an important part in the administration of justice. Its importance and function in society does not diminish over time, but how it operates may need to adapt with times. For example, technology has been utilized by the court to more efficiently and effectively manage cases. Launched in 2013, the e-litigation system gave a better overview of the case compared to the previous electronic filing system, which was more document-centric. In the same vein, clauses 2 and 19 of this bill enable the Court of Appeal and the High Court to conduct hearings via live video technology. This bill is important as it provides the necessary adaptations and tools to ensure that judicial resources are used judiciously in a manner that can best uphold rule of law and administration of justice in an effective and meaningful manner. In civil cases, property rights, livelihood, and day-to-day provision may be at stake. Often, pending court proceedings and unsettled disputes are disruptive to the individuals and businesses involved. Timeliness of a just outcome is therefore imperative. While a case is pending, landscapes of different industry sectors may change quickly, swiftly, with commercial opportunities being lost or foregone. At this juncture, sir, allow me to declare that I'm a practicing lawyer. There are three main areas of the bill that I want to touch on. A common thread seems to be ensuring judicial resources are used judiciously, while ensuring that parties' substantive rights are protected. The first is with regard to vexatious litigants. Clauses 10 and 11 introduce a greater range of tools to vexatious litigation. This is to restrain a vexatious litigant from bringing spurious claims or applications that might clog the judicial process and hinder the effective administration of justice. While better calibration is a good objective, would there be more disputes over the fine distinctions each order in the regime requires? For instance, the distinction between general and limited civil restraint order is that the general restraint order is limited to when the limited restraint order would not be sufficient or appropriate. Another question I have is whether it was intended to set out a new and different test of totally without merit. The original test of without any reasonable ground has been retained in Section 74. If so, would the SMS elaborate on the difference between, if any, and the objectives of the two tests? The second area is the development on the number of judges to constitute a quorum under certain circumstances. This is provided through Clause 4 and the new 6th schedule in Clause 18. For instance, a single judge is necessary for a consent judgment, a judgment which the parties have agreed on. As this list is being placed into a schedule, I would like to ask the SMS, what are some considerations that may be taken into account when this schedule is amended? For example, what kind of trends, if any, will be considered? And what factors will go into the decision regarding what level of judicial involvement or what amount of judicial resources are required? The third area, sir, is on appeals. The appeal process, according to Professor Pinsler in Principles of Civil Procedure, I quote, ensures the integrity and correctness of judicial decision-making, preserves the certainty of the law through judicial precedent, develops jurisprudence, and maintains public confidence in the administration of justice, unquote. Therefore, the appellate function of the Court of Appeal is very important, and the amendments in this bill must strengthen rather than reduce the Court of Appeal's ability to discharge its appellate function in an effective manner. Clause 9 restricts new evidence that may be tendered on appeal. It requires all new evidence regarding things that happened before the trial to pass the stringent special grounds test. In particular, the distinction between interlocutory appeals and judgments are removed and seems to restrict the judge's discretion to admit additional evidence. Therefore, would the good SMS explain the rationale behind such an amendment? According to Clause 6, the Court of Appeal may decide an appeal from the Singapore International Commercial Court without an oral hearing only upon the consent of every party. Would the SMS kindly elaborate on the rationale behind this? Lastly, the fourth and fifth schedule introduces more flexibility into what cases are non-appealable and appealable only with the leave of court. The press release states that this amendment is to, I quote, allow the list of matters specified in the schedule to be amended quickly to adapt to demands on the ground, unquote. Previously, the rationale as embedded and enunciated by the Court of Appeal judgment in OpenNet Private Limited against the Infocoms Development Authority of Singapore is as follows, and I quote, the purpose underlying the SCJA regarding the right to appeal is that an appeal of the parties, while an appeal to the Court of Appeal will ordinarily be denied for orders made at interlocutory applications which do not finally dispose of the substantive rights of the parties and which are deemed to involve established principles of law. The middle category, which consists of orders made at interlocutory applications, which lie in the middle of these two extreme situations, may be appealed to the Court of Appeal only with the leave of court, unquote. In light of this, I would like to ask the SMS whether the rationale behind the categorizations has changed. Sir, new times call for new methods, but not necessarily new principles. The amendments in this bill are important as they provide the flexibility and tools for administration of justice to adapt with the times, not to dilute the administration